was taking up the minimum.
Yes.
And I can provide this to you. I haven't had a chance to take Mr. Morrison through it, so I'll go as quick as I can, but if you need it in writing, it can be provided, of course, should that be necessary. The different wording that we were saying we would be contemptible for His Honour Judge Pelling, and it would be helpful to have open page 88, tab 8 of the core bundle, which is the order he made. And the different wording was, we proposed, and I suppose are proposing again, are after the Roman numeral 2, providing the FIFA Club World Cup 2022 live broadcast feed for South Korea to any party other than the claimant or any channels / platforms / services.
Sorry, just pausing. There's obviously a different wording in relation to FIFA World Cup. That doesn't matter.
So I think it should say and or Bob actually, so that it's missing. It should say FIFA Club World Cup live and or video on demand broadcast feed as you've got in the order made below for South Korea, and this is where the change comes, to any party other than the claimant or any channels / platforms / services.
Sorry, channels, platforms.
So channels is being added in.
Services, yep.
Owned and or operated, open brackets, including through any distribution partners, close brackets, by the defendant or its affiliates, comma, including DAZN social media platforms. So that is obviously different because they're not social platforms said to be owned by the defendant as well. That's the difference.
Can't you operate something through a distribution hub?
Providing the feed to a channel operated by the defendant. So, for example, I've been told, trying to get more clarity over lunch break, that DAZN itself has an app which you can download and register and play on any device. You'll be familiar with that, like Netflix, a smart TV, iPad, phone. It also has channels on YouTube, X, Meta, Instagram, and Amazon, which are separate channels that they operate with a DAZN branding on them.
Well, those seem to me to be quite different. I mean, a DAZN app, which is specific to the user's phone, is one thing. Whereas putting it out on YouTube is another.
Well, it is a term of their license from FIFA that all of the games have to be free to air in every territory. That's not in dispute on either side of the court. And your Lordship will remember the reference in the WhatsApps to Mr. Lee being unhappy with that. For your reference, that's Supplemental Bundle, tab 8, page 89. And that, I agree, they're both different things, but that is what an argument about what co-exclusivity means. Because what Coupang was getting was access to the live feed at all through its own channels, as opposed to Nava getting it, or Soup getting it, or some other provider getting it. Then there was a commercial negotiation to be had about, and there are some differences, I'll give your Lordships the references, between the different heads of terms. They are to be negotiated. There's actually minor differences between the first two, and differences between the third, and you'll find those in the Supplemental Bundle, Mr. Hawke's exhibit. They're pages 39, 51, and 64.
Sorry, page 39.
51 and 64, and what those are references to is the specific exclusivity provisions, and they vary slightly between the first two, and they are different. The third one is different again. And the only point I'm seeking to make, mindful of His Lordship's point that none of this crossed the line, is just that these are terms to be negotiated as to what that means, as to what we can and cannot do commercially.
There's two different questions here. I mean, first of all, you're relying upon this in supporting your submissions as to whether there was a contract at all. And we've got that.
Yes.
But by this stage of the argument, we suppose that there is a contract. And then the question is, how is the contract to be fleshed out. Now, the judge had to do the best he could with the material available, didn't he?
So my submission in response to that, my lord, would be that if that's not a matter, but the matter before him was not the parties had defined that and knew what it meant, and there was no dispute about it. One has to assume on the basis of the evidence available, they would be going on to, on the judge's basis, to negotiate that in round two, the long form contract or the heads of terms, whichever was coming, and they hadn't done so yet. So to impose his own meaning on that in advance of that being done,
I don't understand that. But we assume for this purpose that there is a binding agreement, yes? And you make the point, which I don't think is in dispute, that that was incomplete. There were further terms to be negotiated and included in the long form agreement. And to be sure, the long form agreement would have included precision as to the extent of the exclusivity and whether it included clips, rights, and all of that kind of stuff. But ex hypothesi, there never was any long form agreement. And in the absence of a long form agreement, the judge had to do the best he could.
It's not, I'm sorry, perhaps I'm missing the point, I do apologise, but we were told to specifically perform this agreement, and therefore we were trying to work out what that meant. So, in order to offer that means going on to negotiate, by the way, because FIFA requires you to have a long form agreement. So there will be a long form agreement if the court order stands, because we will have to go into that stage of negotiation.
Not in time. And the judge's point is, I've got to decide this now. It's no good by saying, I'll throw out my hands and you can all go and put in some further submissions and negotiate or argue about it later. The thing's about to start. And speaking for myself, that seemed from a case management point of view quite a sensible way of going about it. And my Lord's point is, if you have got to the stage of a binding agreement that's subject to further terms, then the law implies that they will be reasonable terms and decides what that is in terms of time for payment and so on and so forth. So what the judge was having to do was to decide what would be a reasonable term to drill down to by way of specificity from the agreement on non-exclusivity.
And that's what my solution is that it wasn't the type of term you could imply for reasonableness or necessity. It was a more complicated, layered commercial term between parties to be hammered out.
No, but you're suggesting the judge couldn't do it at all.
I am suggesting that. I'm suggesting that what he should have done is constrain it to its basest possible meaning and allow the parties, for there may have been time at that point, to negotiate with that in mind, whatever they wanted. But let's say now we negotiate the term that I've given you in the heads of terms. Do I have to come back to court to get the injunction discharged because I've got a contract that allows me to do it, but a specific an injunction which prevents me from doing it?
I don't want to take up too much time, but essentially the debate before the judge was, you said you want to do this, they said it ought to be that. I mean, did they have to wait for a negotiation in which you'd formally fail to agree on that?
My single submission, which whether it finds favour or not, is just that it was an overreach because it wasn't a term he was able to imply from reasonableness or necessity in my submission.
Thank you.
Thank you very much. Mr. Morrison,
Thank you, my lord.
can I just say before you get going, we've been assessing timings. We absolutely need to stop ourselves by 4:15. And for that purpose, I think we need to be in a position to rise by 4 o'clock so that we can work out what, if anything, we can tell the parties. Now, I know that Miss John has had longer, but she's also covered a lot of the ground that you might otherwise be covering. So our current view is that you need to sit down by 3:45 at the latest, earlier if better, you know, but 3:45 and tailor your submissions to that.
Thank you, my lord. I've heard that loud and clear. I'll cut my cloth accordingly. My lords, I think it is both parties' case, at least at this stage, that this is a case that turns on its facts. Other than the brief debate about the role of the appellate court, I don't think any significant law was cited by Ms. John, and I propose to take the same approach. I'll focus on the documents that we have and the other matters that the judge decided arising out of those documents. Now, my lord, our starting point is that the judgment is the document that is here under appeal, and what the judgment decided should be read closely. The judge carefully reviewed the relevant facts and documents, including the extensive and documented exchanges between the parties via WhatsApp. He focused in particular on their pre-contractual negotiations that made it clear they had agreed all the essential terms in principle by the 27th of February. The emails of 27th February and 3rd of March, which on their own terms, we would say, the judge agreed, constituted an offer and acceptance, but where the parties' other surrounding communications, we would suggest, put that point beyond doubt. And the judge looked at the parties' post-contractual communications, addressed the points that my learned friend had raised, and explained why they showed that the parties understood themselves to have agreed a binding contract. And we would submit on appeal, as we did below, that the weight of that material overwhelmingly supports the conclusion that the parties intended themselves to be bound as of the 3rd of March. Now, my lord, DAZN in effect asks the court today to retry that conclusion. And as a starting point, I'd submit that the Court of Appeal should approach any such attempt with caution. Now, your lordships took my learned friend through the authorities, including the Water Lily decision from Lady Justice Carr. And my learned friend, I think, accepted that there needs to be at least some deference to the trial judge for factual questions, in particular, both factual findings and also evaluation of facts. But the proof of the pudding is in the eating, my lord, and in the course of her submissions, there was scarcely any attention, I would suggest, paid to the judge's decision on a number of key points. Indeed, it was implicitly assumed they were up for grabs, including matters that were clearly factual findings based on the totality of the evidence he had reviewed. And I would just like to highlight for the court, lest it be lost in the way the case has been presented. This was not a case merely, although it is important, about the WhatsApp exchanges, and I will spend a lot of time on those. But the judge had before him 4 witness statements, which were considerably detailed. A number of other documents, some of which are touched on in the chronology, including internal communications that cast light on what was going on the DAZN side of the line. And I'll try to avoid getting bogged down in that. But as I said earlier, those were in the bundle and submissions were made by reference to them. And he drew a number of factual conclusions in light of all of that material, which is impossible for us to go through now. I think it was briefly suggested, perhaps, that this appeal was almost longer than the trial below. No, my lord, I just want to correct that. The first trial was a day, that's true, the main trial. There was then most of, I think, at least half a day arguing about the implications of the decision for the order that should be made and what the terms should be, and most of another day dealing with the injunction. So it spanned 3 days of argument, albeit not all of those days. So there was a considerable amount of detail. I didn't appear below, but I have read the transcripts, and there's a lot there that hasn't been canvassed today. Just to provide one example, in other words, just to sort of show how this matters. There's a submission which I think, to be fair to my learned friend, was perhaps not focused on as much today, but plays a big part in the written argument, that this exchange of emails couldn't be a contract because it was so brief. You'd expect a lot more detail. There were lots of other matters which were essential and important that weren't agreed. She no longer pursues, I think, an argument that those points denuded an otherwise binding contract of effect due to reasons of uncertainty, but I think she still maintains the factual point. But the judge dealt with that in some detail in his judgment. I'll just briefly show you, in other words, by way of illustration. If we look at page 106 of the core bundle, I'll come back to elements of this, but at 17, the judge decided the relevant approach. And then at 18, if you have that, he says, in my judgment, applying these principles, the exchange of emails constitutes an agreement because, to all outward appearances, the parties agreed the same terms containing the same subject matter. And then he says at paragraph 30.2 of the amended defence, and to an extent in oral submissions, this is by my learned friend, an attempt was made to suggest all the essential terms had not been agreed. I'm not able to accept that is so. And then he goes, over the course of 18 and 19, to give, in the context of this case, a fairly detailed summary of why that's the case. He gives a few examples that played a big part in the trial below that don't stand up to scrutiny, because they're not essential terms, the rest of 18. And then at 19, he notes, and of course you've got to read this against the background of the FIFA contract, which, and I must emphasise, was not in existence at that time, but is incorporated by reference, even on my learned friend's case, into the binding heads of terms that were also agreed before it came into existence. So I think it is common ground that the FIFA contract would always, in effect, would have to be back-to-back with any sub-license, and that fills in a number of the other gaps. So those are a series of findings about the essentialness or otherwise, in light of all the evidence, of the further matters my learned friend says were important. I mean, I don't recall, and apologies, it may have been I was looking at something else, but I don't recall any of this bit of the judgment being mentioned, let alone challenged, in the course of this morning's submissions. And there's a number of other similar points. So I would suggest that, absent a cogent argument, and on this point at least one hasn't been deployed at all, these findings have to be the premise for today's analysis, and there are a number of examples of those type of findings. Just picking up one other, just purely practical point about the nature of the trial, I think it was my Lord Justice Popplewell asked if it was a preliminary issue. I apologise if I misattributed that. Strictly yes, but the only thing that wasn't in the preliminary issue was the claim for damages. It was therefore almost as if it was a split trial where the damages claim was parked, because it would be moot if, as in fact happened, the specific performance remedy was granted. And so in effect it was the only trial that will be needed, assuming depending on the outcome today, of course, but assuming everything goes well from here, there won't be any losses, so that will be the end of the dispute. The final introductory point was to do with the role of the conflicting witness evidence. Now, I propose to address that perhaps where it arises in the course of the argument, because there is, I think, a dispute on the what the party's evidence says about market practice and what the upshot of that is. Now, I'll come back to that. But as I touched on in my brief intervention this morning, there are a very significant number of points where the witness evidence, particularly of Mr. Lee, relates to what he was discussing with Mr. Radhazan. That material is explicit and clear in his witness statement, and it's consistent with, and in many cases corroborated by, the WhatsApps. Mr. Radhazani could, of course, have given a witness statement, and there's been no suggestion he was unable to. He didn't. I don't believe it has been argued otherwise explicitly, but the judge below clearly considered he could, and he was right to consider this, accept what Mr. Lee says is correct, unless there was some basis to contradict it. But there were a couple of points today, I think, perhaps only a couple, where my learned friend suggested that what Mr. Lee says may well be wrong on these points. Now, I'll come back to those and show why there is actually documentary support. But even if there wasn't documentary support, there's simply no basis for going behind Mr. Lee's evidence on those issues, or the judge's findings based upon them, in the absence of any competing evidence from the other side. I just wanted to pick that point up as a point of principle. Turning to the...
Well, one of Ms. John's points was that they couldn't have been expected to, because on the pleadings, there wasn't an averment that they could have been expected to bring Mr. Mancini to give evidence to me.
Well, my Lord, I can show you the pleadings if that's needed. I mean, I would submit that that is simply wrong in its own terms. There's a clearly pleaded allegation that there were negotiations between Mr. Lee and Mr. Radhazani, and that is the background to which the email on the 27th of February was sent. And in the course, obviously, of the way in which the dispute developed, anyone looking at any of these documents, of course they were disclosed, my Lord, these WhatsApps were disclosed, would have seen that the overwhelming weight of communications was between those two individuals.
Looking quickly at the pleading, because
Yes.
like what you were saying, I was just glancing at it myself. So tab 13, pages 131 to 132. I picked it up at paragraph 10.
Yes.
Negotiations were conducted by Charles Marr as well as Andrea Radhazani.
Yes, that's right.
And it's pleaded that Mr. Radhazani was and remains a director of, and then the amendment makes it indirect parent company. As apparent for these matters, Mr. Marr and Mr. Radhazani had actual extensive authority. 12, Kim emailed Radhazani and Marr, and 13, reference to again to Radhazani being a director, and so forth. So, as I understand it, the point you're making is that on the face of the pleading, he was pretty heavily involved.
That's right, my Lord. Very, very plainly, his role is an issue on the face of the pleading, both.
But I think the point that's taken against you is it's not their say. If anything that was said during the course of those negotiations is relied on for the purposes of whether there was or wasn't an agreement. You just start paragraph 12 with the 27th of February email.
Well, so my Lord,
Whereas I do appreciate that Mr. Lee, in his witness evidence, does address some of that.
Well, I would. It's obviously a pleading that's prepared before I was involved, but I would defend this on this point. I would submit that if we look at the totality of the way that the case is pleaded, and bearing in mind, of course, it's all been pleaded quite quickly, with no reply to the factual story as pleaded from para 10 through to 11 puts Mr. Radrazani's role in conducting negotiations from the last week in January up to 27 February 2025. It is on the face of the pleading.
It's also referred to in paragraph 23.
Yes. Sorry, I didn't want to take points out of sequence. But he clearly the contextual point being made there, I think obviously pleading should be a case for argument, is that the negotiations have spanned the period up to and including the date on which the email was sent. And then there's a positive pleading that on the 27th February email is to be properly construed as a contractual offer. And I would suggest that it is obviously implicit in that, if not explicit, that the pre-contractual negotiations are being relied upon. And that point, of course, was well understood because pre-contractual negotiation points are taken, I think, in the course of the evidence that was filed by my learned friend, but they don't file evidence from Mr. Radrazani. And I mean, I don't need an adverse inference because there's no need to go that far because there's no other means and no effective challenge to Mr. Lee's evidence. But if I needed one, it's pretty obvious, I would suggest, that if they could have got evidence that assisted them on those questions, they would have done. And the obvious inference is that he was unwilling to provide that evidence. Of course, you can look at the WhatsApps themselves, and they bear out entirely, I would suggest, what Mr. Lee says. So I'm not relying on Mr. Lee's evidence alone, but I would submit it would be legitimate to do so on these questions if it mattered. Of course, Lord Justice Arnold did mention as well, he is mentioned in relation to the post-contractual communications, so that is significant too. And my learned friend has relied quite heavily on those at trial, the Radrazani communications, so I would have suggested that it must have been obvious at the point of drafting witness statements that those were matters on which he would be expected to give evidence. That point I would suggest is further emphasised by the way the case was presented today. I don't intend to take it, maybe it was a slip, but there was definitely a point in which it was being suggested that the nature of the relationship between Mr. Lee and Mr. Radrazani was significant. Perhaps it went as far as to suggest, I think there was a hint, perhaps, at one point, of impropriety. And there's no.
And that was disavowed.
Yeah, it was disavowed. That's very well known. But that was there's been no factual basis for that at all. The weight of material shows him negotiating in a friendly way, but nothing other than a proper way. And the fact that the nature of their dealings would be relied upon as a reason to allow this appeal must surely demonstrate, assuming a submission otherwise has been forced at all, that DAZN appreciated Radrazani's role was important. You'd expect that role to be explained best by Mr. Radrazani, but they didn't. So they must have understood the point as an issue. Now, my lord, just turning, turning to the substance of the appeal, just by way of a brief introduction, I've explained the way that we would approach matters by reference to the totality of the communications. DAZN's case, I would suggest, in writing, really didn't engage with the pre-contractual communications at all. And in fairness to Miss John, she has engaged with them in rather more detail today. But that the submissions as made suffer from two significant flaws. One is that they omit a number of really quite significant communications. I'll take you through those. But the other mold is that there is, I try to put this fairly, a tendency to paraphrase or perhaps editorialise words that I would submit are clear in context and clearly require an explanation, and replace them with other words that would be rather more helpful for the appellant. And it's important not to succumb to that. The communications are, I would suggest, consistent, clear and coherent on their face. There's no need to adopt a strained or interpolated interpretation. The offer and acceptance emails are then subject to, this is another criticism I'd make by way of introduction, to a exceedingly strained interpretation that takes, I would submit, no proper account of their text. There's a rather different approach perhaps adopted there, but which also ignores the surrounding context in which the parties repeatedly refer to these being offers, to being formal acceptances. I'll take you to that. It's plain when you read these emails, I suggest, in context, that they mean what they say. And then the post-contractual communications, again, there's a sort of, at that point we move away to the opposite approach of saying don't focus too closely on what the parties say, they're not lawyers. You can abstract to some rather different meaning. But there's no need for those contortions. When the material is viewed from beginning to end, and the ordinary meanings are applied, I suggest the story is absolutely clear. They were negotiating a deal in principle. They agreed over the phone a deal in principle, Mr. Lee and Mr. Rabrizani. Then there was a self-conscious switch to a more formal method of communication, email. It set out the essential terms. There's no effective appeal against the argument that they're essential. These are the essential terms. That is considered at the senior management level within DAZN. And then there's confirmation, that's a word that's used. Formal acceptance, that's another word that's used. And just simply acceptance of your offer that comes on the Monday, when it's all they'll get their official response. It really isn't open sensibly to suggest that is anything other than a move from informality to relative formality, from a move from agreement in principle to a contract. And post-contractual communications aren't necessary to reach that conclusion, but they entirely underwrite it. It is clear from the post-contractual communications, I suggest. That's what the parties understood themselves to have done. And it's important in this respect that I think my learned friend got close a couple of times with the defence. I don't think she pushed it, to trying to suggest that Mr. Marr and Mr. Rabrizani kind of weren't the relevant individuals for these purposes, that there were other people that mattered, because they had authority to enter this contract. There's no appeal against that. So their views and what they had agreed do cast meaningful, as expressed, do cast meaningful light on what had been agreed, and they can't be disowned or otherwise diminished. With that in mind, my lord, now I'll temper this section of my notes because, as I said, Ms. John did go through quite a lot of detail. I was intending to go in the remainder of my submissions, first through the relevant facts, and I'll pick up the bits that you haven't seen, perhaps putting what we would say is the relevant context, a few bits that you have, and that will perhaps occupy the bulk of my time. Then I won't make submissions on the law unless your lordships need assistance, because I think that is not really in dispute. I'll deal with our arguments, our positive arguments, why there's a binding contract, and I'll respond to Mr. John's points, and then I'll deal with the injunction at the end. Of course, if your lordships wish me to cover anything I've skipped over, perhaps in the interest of time, perhaps because I've missed it, I'll of course do so. Now, my lords, looking first at the facts. I've got an important starting point here, and again, it's a point from the judgment, is that these are extensive negotiations. I think that was questioned today over a considerable period of time. And it's important in dealing with that factual question. Firstly, I would suggest to start with what the judge said. If we can have a look at the judge's decision, which is behind slide 10, so I will say. Find what it references. This point is dealt with at 17, which is page 105. And obviously, your lordship to be familiar, the judge set out not all, that wouldn't be proportionate, but the more important exchanges. And he says it's now, if your lordships have that, it's now necessary to consider the effect of these exchanges. And then he says, and this is a factual finding, by the time of 27th February and 3rd March of 2020, there have been significant negotiations on what the parties considered to be the essential commercial issues that had to be resolved. And an agreement had been reached in all these matters other than price. So that is his summing up of the effects of these exchanges. Again, if my learned friend wants your lordships to substitute a different finding, then she would have to persuade you that the judge's views, based on the material I mentioned earlier, were wrong. And not merely just wrong in the sense that you might have reached a different conclusion, I would suggest you shouldn't, but sufficiently wrong that you should substitute your own judgment. But that conclusion, my lords, are amply justified by the actual detail of the negotiations themselves. And I'll just pick out a few points, because being fair to Ms. John, she did take you to quite a few of them herself. There are a significant number of points that are dealt with in the course of the negotiations. The first, which is resolved quite early on, concerns FIFA's requirements. And your lordships would have seen the exchange, which shows where on I think it's the bottom of page 86 and the top of page 87, where there are various documents and voice notes, and we discussed that, so I don't think I need to go over that, being provided. And at the bottom of 86, it says these are the general rules confirmed last night with FIFA. Please let me know if this is acceptable with your latest offer. And at that point he's saying considering 50% of the games, obviously that changes. And there's a response saying that the sponsorship guidelines seem to be fine. And there's various conversations, of course, taking place around this time. Now, the judge's finding in relation to that was that the general rules of FIFA had been agreed. And that's at paragraph 8 of the judgment. It may help to have both these open, because perhaps in distinction to Ms. John, I'll be looking at both the documents and the judge's conclusions rather than simply the documents. At the bottom of paragraph 8, on page 100, he says, Mr. Redrosani texted FIFA's general rules, which were then agreed. And then there's a reference to the messages. So that's the first thing. That's relatively straightforward. The two other big issues are the nature of the exclusivity or not, and the price. I think those really are, what's the product and what are you paying for it? Exclusivity is harder, and I don't think I need to go back through this again. I'll attempt to paraphrase this for the reasons of time. But clearly, my client wants exclusive access in the sense it will be the only party broadcasting the games in South Korea. It makes clear it won't accept non-exclusivity, so it can't have a South Korean competitor, Coupang's rival, broadcasting things in the same way. That would be pointless. It would prefer that DAZN doesn't broadcast the games on its own platform, but it's told that's not possible. And so you inexorably end up, what's the middle ground? Co-exclusivity, where DAZN can broadcast the games on its own platform. Anticipating the injunction argument, that's what the injunction involves. And so can Coupang. But you can't have a situation where, literally in the sense there is a sub-license, or functionally in that there is an effect a sub-license, DAZN pushes out the broadcast via another third-party platform, because that would denude the concept of co-exclusivity of any meaning. And I can take your lordships through it, but I think you've seen it. That's what's thrashed out in that issue. I'll pick up one point though, just because I think it's a way of illustration of the type of the risk, perhaps, of the very swift cancel we had this morning. And Ms. Strong was doing the best she could in the time available. But if we look, for example, at page 88, it was suggested, there's a discussion towards the bottom of the 6th of February. Do you see that on the left-hand side, my lords? He says, and he says, I can't consider anything less than 1.5 million. And then there's a phone call. And then I think Ms. John said, and I'm paraphrasing here, nothing much happens until the 20th of February. But that's not right, my lords. Because there's another phone call. Let me know when we can speak. And then if your lordships are scanned down, you see there's a whole series of nulls on the 11th of February. And this is what I mean by saying Mr. Lee's evidence is supported by the contemporaneous documents. Mr. Lee says there were a series of negotiations, including on price and exclusivity. And what we see in the WhatsApps is they are having a series of phone conversations. So some of them might be missed calls, but you can see contextually that they're trying to arrange a call, and clearly at least some of them are successful. So there are events going on here. They are negotiating through this period. We don't see all of it in writing, but it's definitely happening. And it's that then takes us to the 20th of February. That fills in a gap in the summary we were given. Then, my lord, the next point I'd like to bring out, just perhaps a little more clearly than it was earlier, is how this 27th of February email arises. Because, I mean, I think a point was at least at one point taken to us that this is not an offer, this is a proposal. Now, I've got submissions on that, but it's worth looking at how it arises. There is a specific discussion, if you see at the top of page 90, my lords, where Mr. Lee is asking, let me go back one page for this one, I don't want to miss this. On 89, if we look at the 20th of February, Mr. Redrosani says in the middle at 5:29, let me know in the next days if you were interested to make an offer. And Mr. Lee says, I will provide an offer, don't worry. Please accept it though, ha. Ms. John did mention that, but I think she mentioned it about an hour or so after she discussed what the offer email meant. And it's important to recognise the chronological sequence of this. He's asking, will you make an offer? Yes, I will. And when we come to the 27th of February email in chronological order, it needs to be interpreted accordingly. They then discuss the pricing issue. And they are pressed, my client is being pressed, to make a final decision. That final decision, Mr. Lee's words, you can see that about 10 lines down at 6:15 on the 25th. And Mr. Redrosani says, I need to know today or tomorrow morning at the latest. Mr. Lee says, I'm speaking to Stephen on Thursday.
Sorry, I've got lost. Where
Right,
are
sorry.
you?
So if we just look at, if we can look at, perhaps if we go to 7:14, sorry, I'm condensing my original submissions, but
Yeah, no, quite.
do tell me if I've condensed them over much.
Yeah, I see, yes.
At 7:14, he says, Mr. Radrazani, I need to know today or tomorrow morning at the latest,
Yes.
John. So that's 25th or the 26th. And then John Lee says, I have my meeting with Stephen on Thursday, who's an internal person at Coupang. Can it wait till then? Give me a bit more time. And Radrazani says, Thursday, my morning. So Thursday is the 27th of February. So that's the background. And then he says, thanks. And he says, Andrea, let's talk your morning time on the 27th. You can see that a few lines below. So there's a request there for a phone call. This is important because Mr. Lee's evidence, and there's nothing to contradict this in the evidence from DAZN, is that they then spoke and agreed the key points in principle. And that is accepted to be an agreement in principle. I think Ms. John said this morning that there was no evidence to back that up, no documentary evidence. I've made my point about Mr. Lee's evidence being uncontradicted, but there is documentary evidence to back it up. It's right here. He's been asked to reach a position by Thursday. They then arrange a call on Thursday morning. You see the null, and the exchange collectively takes about 30 minutes. And then Mr. Lee says, I can't find your email. Now, Mr. Lee has said that what Mr.
Where is Mr. Radrazani? Is he in London?
I believe he's in. Oh no, I would stand to be corrected. I thought he was in Asia, but if anyone knows better.
I think he might be in Italy, my lords, but if we just assume he's in Europe, in a
Yes.
European time
Yes,
zone.
that makes sense.
he does talk about going to bed at a time
Yeah.
which is
I don't know if it's London or
That's
somewhere else in Europe.
6 in the morning by this
Actually,
time.
that would make sense because he has to be spoken to in the morning, and if these are the Asian time, 7:15, say 8 or 9 hours earlier would be European time. It would be the morning. But what Mr. Lee says in his evidence, and I can take you there, my lords, but he says after we reached our agreement in principle, Mr. Radrazani asked me to put the points in an email so it could be taken forward, and that was a self-conscious move to formality. That's my spin. And then, of course, we see at the end of this phone call, I can't find your email. So he says, actually, I've realised I don't have your email address. That very much bears out Mr. Lee's evidence. Can you let me know again? And then he says, 3 lines below, sorry, thank you for everything. Great to do a deal with you. That's working something bigger. Now, I accept that is, at that point, a reference to the agreement in principle. And it's worth just pausing and going a little bit ahead to contrast that with what happens on the 3rd of March. The reference that comes back then is Mr. Radrazani, deal is confirmed. So at this point, he's done a deal with Mr. Radrazani. No one's arguing that's binding in itself. The moving to email, then it's confirmed on the Monday, 3rd of March. So at that point, the email is then sent by Mr. Kim, and it needs to be read in light of everything we've just seen. If we turn to the email, which is right at the back of the bundle on page 281. Just pausing by way of a brief recap. Mr. Lee has been asked to make his offer. We've discussed what that offer is going to involve. It's been agreed with Mr. Radrazani in principle. He's asked to input that offer in the. Here it comes. Mr. Kim says, I then John. Then it says, John has asked me to send you the proposal below, which captures our intention for acquiring the upcoming FIFA Club World Cup media rights this year. Now, my primary submission, my lord, is that even on its face is obviously an offer, which could have binding contractual effect. I find it difficult to follow some of the submissions that are made against us. The word proposal and offer, as the judge found explicitly, don't appear to make any meaningful difference in this context. And capture our intention for acquiring the rights. I feel perhaps it's just the impressionistic way it strikes someone, but my learned friend treats it as if this sentence said, we intend to make an offer for acquiring the rights. It doesn't say that. It says we're making a proposal which captures our intention to acquire the rights. I.e. the proposal here is because we intend to acquire the rights, not we intend to make a proposal to acquire the rights. So it's synaptically very different. That is the, we're going to adopt a narrow textual analysis. That is the answer to the Gibson and Manchester point, where they said we may be willing to do this. If Gibson and Manchester had said, here's a proposal by which we intend to do this, well, the result might well have gone the other way. But I would suggest there's no basis for adopting such a narrow textual analysis, and I can take you to it, Lords. The judge found that again explicitly. He said these are commercial people operating in a commercial context in a fast-moving environment. Your lordships picked up the point, I think, that they, at least on our side, they're non-native English speakers. I'm not suggesting they're not able to use English, of course they are, but it is a factor against the narrow section analysis. And critically, it's all sent against the context of what's gone before, which makes it obvious this is the formal step arising from the negotiation process, and it is an offer. So when you read...
Just as this word offer,
Yes.
you're attaching significance to the use of the word offer in the WhatsApp messages, or not?
Oh, sorry, my lord, I missed the question.
When you use the word offer, are you attaching significance to the use of the word offer on page 89, for
Yes,
example?
so what I would say, my lord, I'd say two things. Firstly, my primary submission is this is a non-point, because the word proposal and offer here don't carry any meaningfully different connotation, and that was the judge's view as well. But my learned friend attached significant weight to the word proposal. If that was capable of meaning something other than contractual offer, when you view it in context, both prior, and I'm taking it chronologically, but prior to this, it's referred to as an offer, and after this, the email response says we accept your offer.
Well, the more serious point that was made is its intention and it's moving on to the contractual phase. I mean,
Yes, the contractual
it's
phase.
more ground 3 than ground 1.
I agree, and I would suggest, and I think our skeleton said the same thing. This really all does collapse into an argument about intention.
And I absolutely follow that, and I also follow your argument on sequencing. But just as to the use of the word offer, if you go back, say, to 89,
Yes, so let me do that.
you do indeed get Mr. Radrizzani saying, let me know if you're interested in making an offer, and Mr. Lee says, I will provide an offer. But if you go down to 5:12 p.m., the last 5:12 p.m. entry, Mr.
Yes.
Radrizzani says, I was going to call you as we do have an offer.
Yes,
But what he means is a bid.
yes. So they have been receiving a rival. I think it was John and I are at even on this. There is an offer that has come in from someone else.
And that doesn't mean a contractual offer, that's a bid.
Well, we don't know, my lords. So it is entirely possible that it is, but there's been no disclosure on any of that. So what he, and it actually, well, I mean, I would suggest that the more natural reading of what we're seeing here is that they would have, I mean, assuming they adopt a common approach across their business, they would have procured a series of email offers to take to their board. But there's just no evidence on that.
Okay, page 91. First hole punch, 28th February, 4:28 p.m. Mr. Radrizzani, we are receiving another offer today from Soup. So is that a contractual offer, or is that a bid?
Same point, my lord. I was just given what appears to be happening here is that they are moving. I don't want to commit the vice of interpolating words when I'm seeking to summarise, but the way that the communications with us, which is all we can see, operate seems to be that we have been asked to move beyond discussion to tell them what our position is, what's our bottom line.
Yeah.
They then take that email. They want to by email because it's a formal process internally, and there's later messages that say that it's been approved by management, and clearly that is what's going on. I would infer that they have at this point, for the various teams that are trying to procure offers, gathered a set of similarly based proposals, and the one that they accept would create a binding contract. If it hadn't been us, who knows what someone else would argue, but I can well see the argument that the other offer would be binding in the same way. But we just don't know. I mean, if this was a point for my learned friends, I'd suggest they fully accept it was an expedited trial. They might have produced the material to back it up, but there's been no disclosure, as far as I'm aware, at all on any of these points.
Yeah.
And that would make sense of the official point that you see later, the official feedback, because they are officially deciding between the various bids that they have received, the various offers they have received. Which is something matters. Just picking up my Lord Justice Arnold's point, and I agree completely, this is I would suggest to them, I think the intention word, I think I've made my submission on that, I would suggest doesn't carry any significant weight, because the more natural reading is this proposal is intended to acquire the rights, rather than this proposal reflects our intention to move forward to make a proposal to acquire the rights. But my learned friend's better point is the reference to the contractual phase, because that is more readily comprehensible. And I can deal with that now, we're going through the facts, or I can deal with it later, but perhaps I'll try and deal with it now. On its face, and actually there's two possible readings. One is that in moving into the contractual phase, that would be because there is a contract. But my learned friend says, and if this was the court's view, I'm happy to accept it, that it refers to the process of agreeing a long-form contract. Oh, sorry, I don't want to paraphrase it. She says it's the process of agreeing a further document that would constitute a contract. But that, my lords, I would suggest begs the question. There's no dispute from the authorities or in principle that the parties can reach a binding agreement on key essential terms and then move to agree a fuller agreement. There's lots of authorities to that effect. They're all fact sensitive. Both sides, I think, accept that parties can move from shorter agreements to longer agreements. And the dispute on the evidence, so far as there is one, is about how short the first binding agreement can be. But I think Mr. Holt gives clear evidence that you would agree at what he calls a binding heads of terms and then move to a long form agreement as well. So that dynamic is clear in the industry. When you read the full weight of material, I suggest it is clear that the parties do expect to agree a fuller form contract. And I know a friend made the point that's a requirement of FIFA. I'm not sure that's an evidence, but let's assume it's right. There's nothing in that that of itself says that they haven't reached a binding contract at this stage. And therefore, the question of whether they have has to be assessed by reference to all the other material. And I recognise that if the reference to contractual phase wasn't here and the reference to draft contract wasn't here, I'd be in a stronger position. But it is in context a relatively small point against my client, if it is a point at all.
Well, that does depend on what it means, because your case below, as I understand it, let me backtrack. This is the 27th of February.
Yes.
Despite the reference to excited to land this new deal, you're not suggesting at this stage that there was a contractual agreement.
Not prior to the
this is an offer, and that's reasonably apparent from. We look forward to hearing back from you soon.
Yes.
And that's the context in which they say eager to move on to the contractual phase. Your case below, as I understand it, was the phase in which we've got a binding agreement, not a long form agreement, but a binding agreement.
Yes.
That I understand. Is that still your case?
So my starting point, my positive case would be yes. That is referring, at least on Mr. Kim's side, to the fact that there would then be a contractual and binding arrangement from the point of acceptance.
I understand.
But
If on the other hand, it means eager to move on to the phase in which the long form agreement will be being negotiated, that doesn't sit very easily with the idea that there was an intention that there would before then be a binding contract, because the reason that's expressed for the eagerness to move on to the contractual phase is so that they can start planning on content utilisation.
yes.
So it rather suggests that until that, whatever's meant by contractual phase, has taken place, they can't start on that planning.
Well, I think I'd say two things. I mean, obviously, I do prefer and impress the first interpretation, and that is supported, as we'll see shortly, by the exchanges about publication or publicity, promotion of the rights. But even if the point is that they're going to move on to the full long form agreement, that's not against me at all, because everyone agrees you can have a binding contract before that point. It's only against me if first they are in fact referring to this almost intermediate position of a binding heads of terms. There's more detail than the email, but less detail than the long form agreement. And there's no binding contract until that stage. And my lord, I would suggest there's nothing in light of what we've seen so far and what we're about to see to suggest that that is the objectively correct interpretation of this email. Because if that was right, firstly, you would expect some reference somewhere, here or elsewhere, to the idea of this intermediate binding heads of terms. And that, I mean, I will say that does not appear anywhere. That's very much something that comes from the DAZN side of the line in Mr. Polk's statement. But nowhere in any communication that crosses the line is there a reference to the idea that first we'll agree an agreement in principle on the phone, then we'll have an email that doesn't really make a difference, then we'll agree a contractually binding heads of terms, then we'll agree a long form agreement. It's clear from these documents that what the parties intend is to move to a long form agreement if they can, but there's no idea that there'll be some further step before then. And it's my learned friend's positive case that is in fact what the parties intended. That just never appeared. And we never saw any of these heads of terms. The first time we saw them was in disclosure in this case.
So can I just understand, it either means, contractual phase either means when we've got a binding contractual agreement,
Yeah.
or it means when we're negotiating the long form agreement, which can be after there's a binding agreement and it is, in the circumstances of this case, contemplated as going to be after a binding agreement, given the WhatsApp exchange.
Exactly so, my
Does
lord.
that capture your submission?
And they can plan content utilisation during that phase. So even if he is referring to the long form agreement, there's nothing to stop them planning content utilisation while that's being negotiated. And as we'll see, they do discuss content utilisation in the next week. And that's a very important exchange I wanted to say.
So just briefly summarising, look, there are actually different points in play. One, as my lord has been discussing with you, is the important question of what is meant by the contractual phase.
Yeah.
And in particular what is meant by moving on to that. I don't want to go over that again. But you also brought in what is to some extent a separate point, although all these points interrelate, as we've already discussed, which is one, you say no reference to heads of terms. Just to get it out the way, to stop you say later, I assume you make the same point about gentleman's agreement and preferred bidder status.
I do, my lord. I mean, those are words and concepts that simply don't appear. But preferred bidder status never appears. If there's a gentleman's agreement, it is the agreement reached the previous Thursday. But everyone is clearly, you can see it in the emails, they're anxious that that's not enough. They know that's not enough because there's this further step now where the offer is considered internally. My learned friend actually paraphrased, I think she paraphrased it, so it comes as a quote in the transcript, but she paraphrased it to the trial judge as the board giving the green light. And we've seen those internal emails in the chronology. This offer, maybe others, go up to the senior management and they're waiting to see what the decision will be. And then they decide to go with Coupang. They don't decide to go with Coupang to another informal, non-binding stage. There's nothing to hint that that's what any of these people think has happened. And I'll show you this in a moment. They think that they have formally moved to a new qualitatively different stage. And I'd suggest that can only be because they understood there was a binding agreement. And so, my lord, I'll show you that, my lords, I'll show you that now. I think your lords have the point that Mr. and Mr. John, I think, is fair, that Mr. Radrazani says we're considering it internally as another offer. Briefly mentioned that. Then he says on the 28th that we need to come back on the Monday, the 3rd of March, for the official step, and maybe the debate as to exactly what officially is being done, but it seems to be notifying the parties as to the outcome of this process. And then we see this. Your lordships will have seen that Mr. Rhodes, and the sequencing, I suspect, is not hugely important, but I think it is common ground. And the judge, again, made findings as to the sequencing, so we don't need to reopen it. First, Mr. Radrazani emails saying deal is confirmed. So something new has happened. Then we get the responsive email, and that's at 280. From Mark. He says, I am pleased to inform you we will accept Coupang Play's offer for the FIFA Club World Cup 2025. And I'll come back to the second sentence. But pausing there for a moment, firstly, he refers to an offer, and if there was a point in the word proposal, I'd suggest that this really does put it to bed. He says it will be accepted. I think, my lords, I'd submit that deals with the intention idea. If what he meant is, I accept Coupang's proposal to seek to acquire the FIFA Club World Cup. Leave aside the nuances, he would never have expressed himself in anything approximating this way. And then it's an offer for the FIFA Club World Cup 2025, not an offer for the chance to be the preferred bidder, to move to one-on-one negotiations of some kind of lock-in period. There's nothing like that, nothing at all. Clearly he thinks this is a definitive step. And then he does say this, and I don't hide from it at all, we will start contract drafting. Hope to share the draft agreement for your review soon. And that, my lord, again, is a reference to the long-form agreement. And as I said earlier, everyone agrees we can have a binding contract before that point. At that point is therefore of marginal relevance. If he'd meant we will start working on the heads of terms, he'd have said that. And he did, in fact, in his evidence, suggests he understands the distinction. So when he refers to contract drafting, he must surely be referring to the final long-form agreement. Then, my lord, there's one more step, and this is important.
Just before you leave that, what do you say about the word "we will accept"? Johns didn't, I think, suggest with any great vigour that was the use of the future tense. Do you say it actually just means we accept or we do accept, and it's an example of not very not the sort of English which a native English speaker would.
Yes, my lord. I mean, I suggest even a native English speaker could be forgiven for assuming that means the same thing as we accept in this context. If you're saying, will you do this? Yes, we will. Yeah, he is clearly here saying, we hereby accept.
Willing in the sense of are willing to.
Yeah, but not willing to in the future, but we confirm our willingness to, and here it is. And I'd suggest that's the obvious actual English language interpretation. I think the point was pressed below. It was, I don't know if it was mentioned today. If it wasn't mentioned today, I thought that was because it wasn't being pursued today. I'd suggest there's a good reason for that, which is that it's an extremely strained textual interpretation in any context, given perhaps hearing the points from your lordships, points about language and commercial context, as found by the judge. I'd submit it's a bad point. This is clearly understood to be an acceptance, not a notification that in the future an acceptance is expected to be forthcoming. And actually, the point that your lordship was about to show you perhaps puts that utterly beyond doubt. And this is an important communication that I don't think my knowledge did mention. And this is what Mr. Marr says just a few moments later. It's in the WhatsApp exchanges, I believe, on reference to Mr. Yeah, I'll just find you the reference. So I've taken myself slightly out of my notes, my lords, just to condense things, but so if we look,
108.
yeah, thanks very much. So if we look at 108, and I don't think Ms. John mentioned this, and I do forgive me if she did and I dismissed it. But you can see here, 27th of February, your various phone calls. Then 3rd, 25, Charles Marr just sent you an email to formalise our acceptance of your proposal for the Club World Cup.
She must have done because this was discussed.
So he,
Because we weren't quite sure whether that was exactly an hour later or a different time zone.
I think I thought the timing question was discussed by reference to the prior communications from Mr. Ragrazani, but he is clearly saying there, and you can see the sequence of timing is just after, that he sent the email, and the effect of the email, I mean, it's obvious on its face, I suggest, and this confirms this is how it would have been understood by all involved. It is an email to formalise our acceptance of your proposal. That deals with the will point, but it goes much further. It is the email that constitutes the formal acceptance. And that reflects everything we've seen today. That the parties communicate informally up to a point. Then they move to a formal process via email, more formal process. Right. The offer via email, consideration at senior management level, and then a formal acceptance, again via email. With an informal confirmation. We saw the deal is confirmed and there's another one here. But the idea that you can interpret that email as just effectively taking matters not significantly further forward, it's just a sort of a gentleman's agreement that's now been written down, I suggest in the context of these communications is fanciful. It's a formal acceptance, and those are not paraphrased words, those are Mr. Marr's words, and he wrote the email and sent it. And he knows that's how it's going to be understood, and it is how it's understood. So pausing there, my lords, I would suggest at this point there is plainly a line. Everyone knows it. Viewing the totality of the communications and viewing them in sequence rather than taking the emails first and then going back and saying, yeah, change anything. It is beyond any reasonable argument that that's how it would be understood by reasonably objective commercial people in the position of the parties. I don't need the subsequent conduct. But the subsequent conduct does reaffirm that this is the correct analysis. Now, my lords, I'll endeavour to do this relatively swiftly, because you've seen quite a lot of this already. On the 4th of March, as you'll have seen...
Just before we do that, I don't think that Ms. Johns referred us to the responsive email.
Yes.
3rd of March from Mr. Lee, which we've got at the top of page 280.
Yes.
Thank you, Charles and Andrea, for the hard effort to make this happen. Look forward to working with you on this project many more in the future. Which I think we would say is the kind of self-congratulatory,
Yes.
or mutually congratulatory language,
yes.
Which is redolent of an element of conclusion in the deal being secured.
And I would say it works on two levels. One is impressionistically, they all think they've got this over the line. They don't merely think, phew, now we're into the negotiating phase. That was difficult. They think they've done the deal. But if we were adopting a textual analysis, this email also supports that. He doesn't say looking forward to working with you to finalise our agreement on this project, or looking forward to working with you to complete the negotiations.
For what it's worth, the timing seems to fit because that's 6:36 p.m.
Yes.
And it's obviously the email is referred to in the WhatsApp at page 108 at 6:41 p.m.
Exactly, where he says he's replied already and therefore I'm not going to send anything. Exactly, my lord. And I've cut a few of these type of points, but you're absolutely correct to pick that up. So you can see them. There's a parallel dialogue on WhatsApp that makes reference to each of these emails. But he's saying we're looking forward to working with you on the project. Now, the project isn't the negotiation or the preferred bidder lock-in period. The project is the utilisation of the FIFA Club World Cup rights, which they are now co-exclusively going to broadcast. And that's relevant both because it shows that Mr. Lee understands the deal is now being concluded and there is going to be a co-exclusive arrangement, not just a hope of one, but also because it provides context to the exchanges we're about to look at about public publicity. Now, I wasn't going to dwell on the, because I think you've seen them, on the communications that show at this point a kind of rogue element enters the world, where it looks like the Japan office of DAZN summons up another bidder, another offerer, if you want to put it that way. And they like that offer. It does seem that the difficulty is perhaps at a senior management level, the senior management decide if they're going to prefer ultimately that on a bid. The question is whether they're entitled to do so. But if we look at what the individuals who negotiated the contract up to this point, whose communications crossed the line, say, it is, and of course they have authority to do the deal, that's not in dispute, it is completely clear that they think the deal is done. And they are all mutually outraged at the idea that anyone could do anything different. I suggest that's obvious from the communications on the 4th. I wasn't intending to go through those again. I looked through briefly some stuff a little later on the 12th and 13th. But in the meantime, they're all confident this won't be a problem. They say that, you know, we're going to stay with your deal. It's been approved twice by management, I think is a phrase also used. So they progress to begin to implement it. And it's in this context that Mr. Kim emails, or WhatsApps, I should say, Mr. Ma about publicity. And I think it's very important both to look at what was said, but also what the judge decided about this, because actually he addressed this in some detail. If we can perhaps look at the underlying exchange first. So because I've come completely out of my notes, so I might just take one moment just to go back to where I would have gone to on this. Yeah, so we're looking at page 109. And this is where it's vital to read the whole exchange. So first, as you can see, my lords, at the top of the page, and this is, I wasn't going to go into this in detail, there's a reference to this issue with Never's new offer. That is, it looks like we're in a good spot. There are nothing to change. Yes, this is accurate. I don't think we're going to be moving from our existing position. I think it was briefly suggested that suggests they have the option. Excuse me. But clearly, in context, what's being said there is I don't think this is going to be a problem because we're going to stick with the. We're not going to argue that we're not required to stick with the transaction with you. But then they move on to sort of substantive steps. And just below the second hole punch, Mr. Kim is saying, we do want to start promoting the Cricket World Cup on our platform. And he says, I suppose we should announce once the contract is sealed. That's clearly the long form agreement. But I think we should start exploring options with DAZN HD. And then Kim says, assuming the contract may take a while longer. So it's important to focus on exactly what Mr. Kim is saying. He's saying we shouldn't announce it publicly until we've worked out all the detail. But we'll, in the meantime, start communicating with people within the industry that we are going to be involved in broadcasting these rights.
I mean, also in HD, they're the Korean club.
Yes, as I understand that, they're the
one Korean club in the competition.
Exactly. They're the reason the rights have value in Korea. I mean, I don't think this is controversial, but obviously it was a home team, and that creates interest. And otherwise,
are you suggesting that interest in Manchester United or Paris Saint-Germain doesn't exist in South Korea?
Well, I may be treading on toes if I suggest Manchester United may be not what they once were in South Korea, but it may well be that they have value with some value without those, and of course we'd all enjoy seeing them play. But it's both parties' case that the reason this had particular traction in South Korea this tournament is because unusually it's a South Korean team playing all these foreign teams, and that doesn't normally happen outside of exhibitions. So that's significant. Now, just pausing there, I mean, if my learner friend's case is right, you'd expect Mr. Ma to respond saying, you're going to talk to the Korean club, what are you going to tell them? That you're negotiating with us? That you might have the rights? But no, he plainly assumes that at least that step is okay, but he goes further. He says, I think earlier you guys start promoting, so that must be the public step, the better. He says, this is my personal view. But he gave evidence that his personal view was there was no binding contract at that stage. It's manifestly not right, given these documents. He thinks the rights have already been agreed. If he didn't think that, he would have responded saying it's premature. Don't do it until the contract's concluded, the full form contract or the binding heads of terms. But he obviously doesn't think there's a problem. Because whatever, and this supports the judge's analysis, whatever there is that remains to be agreed is non-essential. So you can move ahead. And looking just at what the judge had to say about that. Because I mean, again, I don't think there was any real engagement with this. But he spent quite some time on this. Because if we look at 108 of the judgment, and page 23. And your lordships may feel you've obviously read it already, but if your lordships wish to, I'd invite you to read that full text. He's now making, my lords, a series of cogent points, overlapping the points I just made, let's make them first. But the proper interpretation of this exchange is clearly that Mr. Ma and Mr. Kim both think it is legitimate to promote now the tournament. That it is well understandable why Mr. Kim would liaise with Mr. Ma even if there was a binding agreement, because they are co-exclusive rights and they don't want to cut across each other. And he says that's close to obvious. My learned friend says, I think at various points she said it is consistent, equally consistent, that neither of them thought they had the rights. Well, in other words, it's barely even arguable, but the more obvious interpretation by a margin is that adopted by the judge. But critically also on appeal, the judge did adopt it. So if my learned friend now wants to go behind this factual series of findings and evaluations, she has to explain why your lordship should substitute your own judgment, and I suggest she hasn't come close to that. It's another example, perhaps, where the point has been argued as if it was the first night of the show today, and it isn't. Well, there is then another exchange on the same topic, and here it's a point that may have got lost, and maybe everyone has picked this up, but I just want to make sure it has been picked up. It is the interrelationship between the two chains of WhatsApps in relation to Mr. Rodrizani and Mr. Lee's exchange on this issue. Because if we look at the exchange on the 10th of March between Mr. Ma and Mr. Lee, going back to the supplemental bundle, page 105. It's one of the banes of cross-examination, among other things, that WhatsApps are invariably huge documents that interlink with other WhatsApps and they're hard to read side by side. My learned friend's document was helpful in that respect. It did things in order. At the bottom of page 105, so this is Lee and Ma. Mr. Lee, sort of halfway down from the second call punch, is saying, we are planning to start promotions end or early next month, so we need to move quick. And he's chasing for the contract, said it's with our legal. And I think the point my learned friend suggests is that we think we need the contract to go ahead. I would suggest that's not what Mr. Lee is saying, so we'd like it. But then Mr. Lee asked the point explicitly: if we're not able to sign the contract in time, do you think it's okay to start promotions in advance? I mean, that question surely only makes sense on the premise that they knew they were going to get the rights because they already had them. If that was a genuine doubt, they wouldn't be promoting coming soon and Coupang Play, the Club World Cup. Oh, well, it turns out actually we haven't completed a deal to buy it. But what does Ma say? Ma doesn't say, you what? You don't have any rights at all, don't be silly. Because my recommendation is to start promotion as early as possible. And in context, that's obviously meaning before the long-form contract is concluded. And then over the page, and this bit I think just needs to be picked up, I suggest you ring Andrea, that's Mr. Radrazani, and tell him you want to promote this. And understand from Charles, which Mr. Marr referring to himself, contract has been drafted by legal, and tell him realistically the contract may only be fully executed in April, which is quite late. I'm sure he should be cool with it. So the point being made there is obvious in context. Check with Radrazani, but I expect he'll be fine. Explain the contract, the long form contract is too slow. You're going to need to start promotions before it. He'll be fine with that. That only makes sense if they already have a binding agreement for the rights.
Is it really fair to say it only makes sense on that basis?
Well,
I mean, you've been on Miss John's case.
Yes.
You've been selected as the person who's going to have these rights. There's a process being gone through in sorting out the formal document, but you're going to have the rights. That's been decided. You want to do something in anticipation of the paperwork being finalised.
Well, let me take that at two levels. I can see a rationally coherent argument that is formally consistent with the explanation that was just put by your lordship. But I would say it's by far the more obvious explanation, particularly given, and this is important, the emphasis that all the parties place on the idea that there needs to be a moment at which the contract is binding, and before then, all is jeopardy, is that this is not a communication that would be sent by Mr. Marr if at this point he thought he'd had nothing other than an agreement in principle as a result of his emails. The far more likely explanation of this exchange is Mr. Marr thinks the deal is done. That is doubly so where they both know that there's a rogue element in Japan trying to cause trouble, but they also both think it won't be problematic. They can't be, if there was no binding contract, they could have no real confidence that Coupang was going to have the rights. Their confidence doesn't stem from some overestimation of their own persuasiveness, it stems from the fact they know there's a deal and there's no basis to go back into this stage. Now, they could obviously senior management ultimately try to reach a different direction. But that is the view of these individuals. And it's these individuals, of course, who negotiated the agreement. And we then see that is then reflected in the WhatsApp that I think was shown to you that Mr. Lee then sends to Mr. Radrazani. So you can see the sequencing. It's actually slightly later that it's sent to Dennis, but it's at page 92. So about 8 lines down. It says, hi Andrea, all well. We've yet to receive the contract for CWC and was wondering when we can receive it. We plan to start promotion late this month or early next month. Do you think it's okay to start before execution of the contract? So that reflects, I think my learned friend suggested, but this obviously shows that we would need an agreement because we know it's not otherwise okay. But of course it reflects what Mr. Marr had suggested, which is this would be fine. And as the judge found, it makes total sense that you would seek to coordinate this promotion with the exclusivity arrangement. So that's the answer to that point. By far, I mean, if not the only, then certainly by far the better interpretation of this material, and the one the judge adopted on analysis, is that both parties think that their rights are secured, and the reason they're consulting each other is because that follows from the co-exclusivity.
What is unilateral production? I plan to do some unilateral production.
So
who should we talk to about that?
So I believe this is me referring to the witness evidence. There is a element which Coupang adds, where it provides its own Korean language commentary, because that's not otherwise part of the feed, and that element needs to be produced, obviously, only on the Coupang side. And the question is who would be best to discuss that with. I think that's what that's a reference to. I will say though, I don't believe that point was ever explored.
Why would that be something that he asked? Then who should we talk to about this?
In relation to
Unilateral production.
Because I believe it needs to be overlaid. So again, this is my understanding that it needs to be over. So what happens is the broadcast feed comes in from DAZN, and then this is overlaid on top of it. So the technical level.
So there'll be technical questions.
That's my understanding, my lord. Now, I'm speaking not off the cuff, but based on my reading of the material and light of the evidence. But this is not a point on which I think anyone put forward.
No,
any-
just keep it still.
that's my understanding. So the language element is something Coupang adds, and indeed would be expected to, given its Korean targeted market.
Well, not necessarily, I'm sorry. The language is a debated, is a negotiated issue.
Well, I think there's perhaps a debate over that question, but my understanding that indeed supports my interpretation for what it's worth. If it was something that needed to be agreed as one of the details, then that would explain why they would want to talk to someone. But it's not one of the essential terms, as the judge found as well.
Whichever way your lordships prefer. But then we see he never actually gets a response, unfortunately,
Because at this point, it all goes wrong.
Mr. Radharazani says, "I can call you later." And he's like, "Okay, what's the hold-up about?" And obviously Mr. Lee's nervous. And then you, as your lordship's seen, and Mr. John went through this quite carefully, I think,
It emerges that senior management have decided to try and push this other transaction.
and it's quite telling here that, lest things be taken out of context, and I think it was probably fairly chronologically presented. Mr. Lee is furious.
Mr. Radharazani is very sympathetic. He at no point suggests that Mr. Lee is wrong to be furious. That might be consistent with the gentleman's agreement, but I'd suggest it goes further than that.
But then critically, at the top of page 94, let me go to the top of 95, save some time. Mr. John went through this quite carefully. Mr. Lee says, "Can you try to convince him one more time? If he," this is the senior person at DAZN, "is not convinced, we will need to take legal action."
Now that must show, and show Mr. Radharazani that this is Mr. Lee's view, that they understand that they have a legal basis for taking action. That can only be on the basis of the binding agreement. No one else has even identified a possible alternative ground for claim.
If it was objectively clear to Mr. Radharazani,
Or indeed subjectively clear, that there was no agreement, his response would be, "I know you're upset, but you don't actually have a basis for suing us. Don't throw out the baby with the bathwater. You don't want to go down that road."
he doesn't say that. He says, "I'm trying to help you. There's no other choice I know. I understand."
So he clearly thinks, I mean, it's not, I'm not suggesting he's sort of saying the claim will necessarily succeed, but he obviously thinks there is a legal basis for suing them. What can that be? It's because it's a breach of contract. It must be.
And Mr. Lee sort of tries one last-ditch effort to resolve this without that step. And it's in that context, down the page, next to the second hole punch, that he says, "Do you think if we upped our money, that's the CEO,
Would work with us. And in fairness to Miss John, I think she suggested below that showed that this was a gazumping situation. And in reply, my predecessor leading the case for Coupang pointed out that can't be right because he's already threatened legal action. And the judge obviously agreed. The point there is, if we can avoid the need for a claim by renegotiating, I'm willing to consider that. That's perfectly sensible. Obviously, the cost of this action would gross the outlay if they threw in a few more £1,000 that could push this over the line. Very sensible proposal to make. It's nothing more than that
when you see it in the context of the threat to take legal action. And then it switches very shortly afterwards to WP correspondence. That's why we get redactions. So
Litigation's flaming.
contemplation at that stage. They're trying to inferentially settle it.
So, in other words, that takes us to the end of the factual story. And I mean, at the risk of making the same points, there is a clear, consistent progression of events here. There's informal exchanges that are detailed negotiations. The judge concluded as much. The essential terms are agreed. And the judge concluded that too. There's an agreement in principle, which then sets out, supported by the evidence, both witness and documentary, over the phone. They move consciously and deliberately to a more formal means of communication, making the offer. In context, that's intended to have contractual effect. There is then internal consideration at a high level within the zone. Updates are provided. There's a confirmation official decision is about to be taken. Then it's said the deal is confirmed. We accept your proposal, we accept your offer. And then, just in case anyone was confused, WhatsApp saying, "I've sent you an email with our formal acceptance of your proposal." Then the individuals involved move to the next stage. They're all confident that that deal won't be reneged upon, because it obviously considered binding. And they discuss how they're going to publicise and when they're going to publicise the rights that Coupang has acquired. So it's a consistent story. The only credible contrary point, and I acknowledge it's not a non-point, is the fact that emails refer to the contractual phase, and the draft contract. But viewed in context, it's clear that those are references in the first instance, following my exchange with Lord Justice Popplewell, to the point at which there is a contract, or if my learned friend's right, there is something else, I would suggest it's a reference to when they're negotiating the long form contract. The second email referring to the draft contract is clearly a reference to the long form contract. And again, the further references we see make it clear that that long form contract is not required for the parties to take substantive public facing steps on the strength of the rights that have already been transferred. So once that factual narrative is viewed in its entirety and without, I'd put it this way, excessive paraphrasing or editorialising, the judge's conclusion, and the judge adopted, I've perhaps gone through some more documents than he did, and perhaps omitted a couple he referred to, but the narrative is the same. The judge's conclusion that overall the parties objectively made a contractual offer, contractual acceptance, and intended to be bound, is, I suggest, unimpeachable. In any event, it's clearly not one that at this stage the Court of Appeal should interfere with. Now, with this in mind, my lords, I will canter quite quickly, because I'm conscious of my guillotine, just through a small number of responsive points. Most of my submissions have really been picked up around here. The first, and I just picked this out, is that, and I think it was Lord Justice Arnold who asked my learned friend about it. When the dispute arises, there is the exchange that was identified, in which it said it's a good thing that John sent his email. Now, why do they say that? Well, because they consider, I would submit, that they have locked the position down before this other offer came in. If they'd only had their agreement in principle, there would now be jeopardy. But the email exchange solves that problem because they've already got a binding agreement. There's no other credible explanation, I suggest, for that exchange. A further point, which I think my learned friend had her own answer to this, but why did they move to email? Well, the answer is because they're moving to something with a different effect. They're moving to a more formal stage. They need something to show the board. They need something that in writing records the key terms. That supports, again, the conclusion that this is a qualitatively different step with intended qualitatively different effect. There's the point about market practice, and I mean, my lords, the way this is coming, I'll be as swift and sort of candid as I can, really. Below, I don't think either side ultimately put huge amounts of emphasis on this. We saw my learned friend skeleton, and she referred to evidence that said, of her witnesses, that said the best practice was to have a long form contract, and I think Mr. Marr said the standard practice was to have a full form contract. Now, if it matters, my primary submission would be that is consistent with, so far as it goes, Mr. Lee's evidence, which explains there are various ways you can do this type of deal, but where it's a quick moving deal with urgency, you can have an email exchange that's binding. But it's also internally, with respect, inconsistent, because firstly, it rather describes two different concepts, but secondly, it's not consistent with our primary case, which is actually what DAZN does, is have these binding heads of terms, not a full formal contract. So to the extent there's a conflict of evidence, it's resolvable in our favour because their evidence doesn't make sense in its own terms. But if your lordships feel that that's just a matter they're unable to decide, I can well understand why, given the lack of cross-examination, and the market practice point is discounted, I'm perfectly content with that, because it must go with it any argument that this type of short-form agreement is in some way improper in the context of this industry. I don't think I can't have it both ways. Either the market practice issue is live and it should be resolved, in which case it should be resolved in our favour, or it's not, in which case you've just got to assess the documents as you see them. And one thing that's striking is that Mr. Lee's account of market practice accords with what we see in the facts in this case. Whereas Mr.
Well, I don't think it's really right to describe the evidence on either side as market practice.
Yeah, I don't think...
Mr. Lee explains what his experience has been
Yes.
of what happens on different occasions in cases he's been involved with, without suggesting that there's a uniform practice in any particular case. And Mr. Powell suggests that this was their process for this particular sub-licensing in the particular circumstances, which he says was unusual.
Yes, I
So
think...
I'm not sure that we're really looking at market practice, and unless it crossed the line between the two of them, they could both be regarded as being aware of it. Speaking for myself, I don't see how it can help us.
I'm perfectly content with that. I mean, my point in the heads of terms was going to be that they were, not only did they not cross the line, they never even mentioned. It may well be that DAZN use them with other parties, so it seems. It might even be that someone in DAZN intended to use them with us, but they never told us about them and they never showed them to us, so they really have no relevance at all. And I'm perfectly content for the case to be decided on the face of the quite substantial documentary trail we have before us. The point came in really by way of a response to an attempt perhaps to resurrect an argument based on market practice, but I sort of feel the sting collectively has gone out of that, so I was intending to move on.
But while we're on the relevance of the witness evidence, could you just show me in Mr. Lee's witness statement where you say he says something which adds to what we've seen in the WhatsApp messages in terms of content?
I'll show you I'll show you the two key passages. If you look, I'll just get the references. I recall the paragraphs I'm about to show you. So I think
Paragraph 18.
yes, that's right, my lord. So that is the paragraph I had in mind when I showed you those various nulls, because he says here, 18, page 8, that I mean a lot of this is about authority, which is no longer alive. But he says we had calls, WhatsApp and calls over the course of January and February 2025 on various points, and then the topics they covered, and they've actually discussed it internally. I mean,
The only things he picks out are FIFA's contractual requirements for sub-licenses, which looks as though it's a reference to that passage we've seen in
That's right.
the FIFA general rules. Exclusivity, we've seen that in the WhatsApps. And price, we've seen that in the WhatsApps.
Exactly.
So is there anything that he adds to what we see in the WhatsApp?
I'm content with that. I think the question that was made this morning was that we said there were extensive negotiations, and actually look at the WhatsApps, they're all quite brief. But that appeared to overlook the various calls that were taking place in parallel. And I just wanted to show your lordship that he does suggest this was something taking place across this period, not just on the occasions where we see text. But in truth, I don't think
But not on topics.
not
Beyond those
well,
that we see discussed in WhatsApp.
To be fair, I'll just say subject to one proviso, because the other paragraph I show you, my lord, is the next one.
Yeah.
Now that's where he says there's an agreement on principle on the essential terms. And these are again the same points, including the amount and co-exclusivity. And then he does add, and my learned friend I think did rely on this below. I don't think she's made much of it today, and maybe just it's not a point that matters. But he does say we verbally agreed a few more details, such as marketing activities. Now, I don't argue, I don't think anyone argues, either that those are essential, well maybe below it was argued they were essential terms, but certainly I don't argue those form part of this agreement. Those are not among the core terms that found their way into the email. So here he is saying, this is the point that goes beyond the WhatsApps, perhaps, that there was an agreement in principle, although showing your lordship the sort of shadow that casts at the WhatsApps, the phone call and the request for the email. And then he says at the end of this paragraph that I should send him, that's Mr. Representing, an email to formalise in writing what we had agreed. And again, you've seen them, and that's what happened.
Wait, sorry, we just read out a little bit before that, just for completeness. He then told me the board had approved and the deal was done in substance.
Yeah.
Right, well, that doesn't tally with the WhatsApps, is the point I have made.
I'm sorry, was that made today? I didn't hear that today. But if the suggestion, so
Well, your lordship, in that case, may find there's a conflict of evidence on that point. But the point that isn't, I think, a conflict of evidence is that there was a request to formalise in writing what it be.
Hang on, when you say conflict of evidence, you mean on the question of whether the board had approved?
So I fear the distinction may be, and maybe it's loose language in the statement on this point, between the board allowing him to give an agreement in principle and the board conducting the more formal process that plainly then takes place over the following day and weekend. I don't think I would argue, and if it wasn't giving you refers here to an agreement in principle, Mr. Lee clearly isn't arguing that at that point the board has given a final approval to their offer over another. But I infer that is him saying that Mr. Radrazani had been approved to do the agreement in principle and to take matters to the email stage. And it's important to remember the authority issue is, of course, running through this like a stick of rock, because that was quite a big point at trial. So he'd want to avoid Mr. Radrazani seeming to be a rogue agent, if I can put it that way. And of course, the judge found him. So I mean, I hope that answers Lord Justice Popplewell's question. There's a relatively limited amount of ads, mainly because I think the WhatsApps are so comprehensive, but if it mattered, those are the points that come up. And then, my lord, we've covered subsequent conduct, and I think I've made my submissions on subject to contract. I just pick up one point. I think it was suggested, I mean, maybe these kind of points have fallen away in the course of the morning, but it was suggested at one stage, I think the judge didn't identify the need to keep distinct in his own mind the test for a contractual offer and the separate question of intention to create legal relations. The authors may feel that there's no need to address that, not least because in this case the arguments really overlap so substantially. But just to be fair to the judge, I feel I should point out that he did address that. If we look, if we just look at page, I think the best place to find it is 17, page 105.
Paragraph 17.
I'm sorry, yes, sorry. Para 17, 105. He's there saying the parties had reached agreement on all the essential issues, and in that context, the 27th February email was plainly an offer. And then he refers 33 lines from the bottom. The response was an unqualified acceptance of what was and was plainly and reasonably understood by the defendant to be an offer. And then turning over the page, he refers to the parties 3 lines to the bottom. All outward acceptances agreed the same terms, the same subject matter. Because one could understand a situation where they intended to create legal relations, but there was a battle of forms point. That's not this case. And then he refers, and this is the point I just wanted to highlight, 6 lines from the bottom. The question whether the parties intended to be bound immediately, or only when the formal agreement was signed, depends on an objective appraisal of the words and conduct. And I think, I mean, I can address it further if it's cause for concern. It is clear the judge does have in mind there that there needs to be an offer which shows an intention to be bound immediately and an acceptance that unequivocally accepts it. I mean, the language he uses wouldn't make sense otherwise. And it's a little bit like saying, you haven't said we're going to give care in this contract, this context and talk to Donahue and Stevenson. You just don't need to do that to decide cases, I would submit, or indeed to argue. So I picked that point up briefly. And then I think the final point, just on the nature of the judge's finding on the subject of contract wording appearing in the heads of terms. The judge obviously wasn't saying this is a document that crossed the line, not least because he decides elsewhere, rightly, that it didn't. But the argument that had been put to him was that these heads of terms are very important because they represent the normal practice. You can infer more from them than merely what crossed the line. And as I read the judgment, he's saying this showed that DAZN at least understood, because it did so in these documents, that you could put subject to contract on a document if you wanted to make it subject to contract. And to the extent, and I think my learned friend said it's one point among several, I think that's right. To the extent that they were arguing you've got to look at the heads of terms, you can't just look at the convenient bits. He may also have been meaning to say the same point that's made by the Court of Appeal in Immingham, endorsing the trial judge there, which is basically obvious. The commercial parties know you can include explicit wording.
Yeah, but isn't the real point a slightly different one? And I think Ms. John made this point, just articulating it in my own way. The significance of the heads of terms documents, and of course, you're right, it didn't cross the line, that's not the point. The point is that if you ask yourself, why are those labelled subject to contract? Answer, because they go on for pages and pages and are quite formalistic and quite detailed, even though they're not full long-form agreements. And so you might feel, well, there's a need to put subject to contract on that, because otherwise it definitely would constitute an agreement once accepted, a binding contract once accepted. Whereas, if you're expressing yourself much more informally and shortly, as in the email communications, you don't need to put subject to contract on them because it's much more implicit in the way you're expressing yourself in the first place.
So my lord, the point I make, and maybe this is the point your lordship's making, or you may be making a point that could be argued against me, is that if you have a document that is a basis for negotiation, then one can see why, particularly if lawyers are involved, the wording subject to contract would be spelt out. It's worth looking just at the context of the email in that respect. It is not intended to be the starting point for negotiation of a binding agreement on articles. It is the culmination of it. It is our proposal, and it's being considered, and then it's accepted. So there would be no point in adding subject to contract in our review of the world. But if the respondent's response was that this was only the starting point for negotiation, you would expect that to be spelt out with clarity. And of course, my own friend says Mr. Marr's not a lawyer, but he gives evidence. I can take your logic to it if you wish, in which he sort of says he understood the idea that certain things were binding contracts and certain other things weren't. And it says that to support my own friend's case, but it doesn't really lie, I suggest, in the appellant's mouth now to say he didn't really know what the effect of these emails was. He clearly understood he was accepting the offer. He says in terms that was a formal acceptance. He understood what the implications of that were, which is it would be a binding contract. Objectively as well as subjectively.
We can see from page 35, which is one of the draft binding cases, but what we're talking about here are travelling drafts of an agreement which is intended to be binding
That's right.
when signed.
Yes.
Not that when these terms are agreed, it's going to be subject to a subsequent contract.
That's exactly right.
These are the drafts of legally binding heads of terms, which are expressed to be subject to contract and internal agreement.
Exactly so. And what was the point?
So it's like lawyers putting on the travelling drafts of a final contract.
Exactly.
Subject to contract.
Exactly. And Mr. Paul says that. He says this was going to be a binding agreement in due course, but this is the sort of thing, this was the only thing that would be a binding agreement. That's the argument he's running. And what the law, what the judge is saying is that you can see the intermediate graph, so subject to contract at the top. That shows that this party understood that you could, if something was a basis for negotiation, you could appropriately qualify it. It's no more than that.
8, 9 minutes on
I'm
injunction.
very conscious of that, my lord. Well, the good news on injunctions is that, and I'll move on to that unless your lordship has any further questions. Your lordship's questions this morning rather anticipated my argument. The key problem, I suggest, with the analysis on writing is that it starts from the premise there's no breach, so why would I be injuncted? But of course, the judge found explicitly, paragraphs 2 to 3 of his injunction judgment, that the proposed conduct that was being threatened, or at least implicitly threatened, would be a breach. Once he's decided it's a breach, the injunction follows automatically, given the submission that was being made, because this was what the appellant considered it was entitled to do. The submissions that it wasn't a breach were very much, I think, well, with respect, sort of spun up in the course of the discussion this morning by the appellant. But my lord, taking into
Just focus on that, because on this part of the exercise, nobody's actually looked at what the judge said so far.
Well, yeah, I wanted to
in
show
this
you that.
court. So it's the judgment that's in tab 9.
Exactly so. Paragraphs 2 to 3 now.
And he's dealt with the issue first of whether there should be an injunction at all, and you just covered that. Then there's the question about the first part of paragraph 3, which is no longer in dispute.
Yeah.
And the part that's in dispute, he deals with at paragraph 10.
Yes, and that's where he decides the answer. And he's very clear about that. And I mean, I don't want to sort of go into the terminology of how we got here, but reading the transcript below, it was not unlike this morning, where I think the judge initially understood that what was being argued about was maybe clips or something like that, but then it became apparent that the proposal was to stream on YouTube or an equivalent service live the broadcast of all the games. And that was said to be okay by DAZN because it was a DAZN channel which it operated because although it was on YouTube, it had DAZN's logo in the corner. And once the penny dropped that that was what they were proposing, the decision followed inexorably because the whole point of the co-exclusivity rights is that DAZN could still broadcast using its own app and platform, like Netflix, it has its own DAZN app, but that it couldn't, in substance, sub-license or push the broadcast through a third-party provider.
Just to be clear, sorry, go on.
Sorry. So, the reason why I wanted to look at this was I wanted to try and get straight what analytically we in this court are supposed to be doing on this issue. Because I think where we ended up with in Ms. John's submissions is that the judge was wrong because he was not justified in spelling out the terms of the agreement in the way that he did.
Yes.
Because ex hypothesized, this issue only arises if there is a binding agreement. We all know the binding agreement doesn't spell out the details, and therefore it's the judge's job to do so. And so the submission is he wasn't justified in going this far.
Yes.
Now, do you agree with that way of looking at it?
So I think that is where
Well, obviously you part company on the conclusion.
Yes.
But is that analytically the way
Yes,
of
I think that's right. I think, I mean, subject to it being part of the grounds of appeal at all, which I would submit it isn't if it matters, I think Ms. John's ultimate submission is the judge did not have a sufficient basis, and therefore should not have resolved this issue, I think, at all, or possibly in the way that he did. And if your lordship's considered that point was in play, then I would submit he clearly did have a sufficient basis, and I would have 3 or 4 points to make about it. I'm conscious, though, Lord Justice Newey had a question too. So,
there are 2 aspects, are there? There's a sort of procedural aspect. Was it appropriate for the judge to get into this?
Yes.
And then secondly, supposing it was appropriate for the judge to get into this, was he right in saying that this conduct was excluded contractually?
Yes, I think that must be right.
And just going back to what I was going to ask you, thinking about what co-exclusivity means,
Yes.
I mean, it's a matter of sort of common sense. Obviously, you're not supposed to go and take money from someone else to allow them to do anything. But if you've got your YouTube channel, is that quite the same? You're not presumably taking any money from YouTube. It's just a mechanism by which you put out the material.
Well, I'd say 2 things. I mean, obviously, my understanding is obviously YouTube, if you put material on it, would take a cut of any advertising. So to that extent, there is a sharing of revenue. But I don't need that point, my lord, because it's to do with the way in which it reaches the public. Coupang has its own app, which is to sign people up to go to it. There was a debate, you've seen this in the WhatsApps, and this treads into the fact there was a basis for the judge's conclusion about exactly what DAZN was going to do with the rights. And Coupang is a clear cut that it can't have the rights being broadcast on one of its competitors. It doesn't really want to, but it ultimately accepts the idea DAZN can broadcast them themselves. And there's an obvious reason for that. We've all heard of YouTube. Everyone in the world pretty much knows what YouTube is. It has a reach and an accessibility that goes qualitatively beyond any particular service, such as DAZN or probably Coupang for that matter. And if it's being live cast simultaneously through something like YouTube or someone else, and of course, if it mattered, I'd object, but there's no clarity as to exactly what's being planned, which gives us some cause for nervousness, then that will undermine the value of the rights that we have obtained. We understood DAZN might use its own app, but that's all that was understood. And if co-exclusivity means anything, it surely must mean that you can't put it through a third-party platform.
So, this concept of third-party platforms.
Yes.
I'm into territory that Lord Justice Arnold knows much more about. Social media organisations maintain they're not publishers; they're just mechanisms by which material is posted. Is it so different from, I don't know, some more old-fashioned method of disseminating what you want to say?
Well, yes, I think I would submit clearly it is, my lord, in context. Because if we look, for their own reasons, presumably defamation-based, that might suit social media platforms to say that. But that's not the question here. The question is, as between DAZN and Coupang, what is the value in the co-exclusivity right? And whatever the formal status, I mean, you could put not a license at the top of the contract, it doesn't stop it being one. Whatever the formal position, if the very broadcasts we have co-exclusively agreed to broadcast are now being put on YouTube, that's imagine we'll just put in YouTube without more. That must be a breach. Does putting DAZN's logo in the corner denude that breach of effect? I mean, if my learned friend was intending, for example, to put this out on a channel on the Never platform, which is the rival bidder, and add the word DAZN to the corner, that would manifestly be a breach. And if that was their intention, they would have to say so and argue that point. And YouTube is just the same to these effects.
Yeah.
It's a substantive point about the nature of the rights. And while there might be marginal areas of debate, this isn't one of them, is our submission. And that's clearly the way it struck the judge. Now, if it mattered, my lord, I'm conscious I'm 15 seconds, this was part of our pleaded prayer for relief. So part of the injunction as pleaded was that the feed would not be provided to anyone else, not just that it wouldn't be disposed of. The injunction simply works out the implications of that. And secondly, and this is a final point, my learned friend showed you one of the heads of terms. They're completely inadmissible on this issue. But one of the other heads of terms, I can take you to it if needed, says that these rights will be co-exclusive subject to the rights to put things on social media, which clearly in drafting terms suggests it's a carve-out from what the co-exclusive right would otherwise involved. Mr. Polk refers to co-exclusivity in an unqualified way, as if it's obvious what it means. I mean, this is not a confusing term. in the context of what we're discussing now. It's a well understood term.
And
There is an evidential basis.
sorry, I know you need to sit down, but page 136, your particulars of claim.
Yes.
C is injunction, a final injunction prohibiting DL from providing the broadcast feed to any party other than Coupang, which intends to broadcast in South Korea.
So that's what has evolved into the second limit, because my own friend
Right.
wanted to make sure that it didn't inadvertently cut. Well, she wanted to obviously argue this point too, but she wanted fairly to make sure that they were allowed to put it on their own channels.
And just to be clear, if you, there was talk earlier on of TikTok or X or whatever. So if you provide the material by posting it on X, are you feeding it to another party?
What we would submit, yes. If what it is from the user's perspective is the broadcast feed, or if it matters, the video on demand, so you're just watching the live game, that clearly is a person providing it to that party. It must be. I mean, even if they're not strictly speaking, publisher, you're providing it to them because then they're pushing it out onto the internet. It's their URL at the front of the name. And from the user's perspective, that's exactly what it would look like too. So it would clearly be a breach. And I think, with respect to my friend, once the judge appreciated that's what was being proposed, he thought the answer was obvious, and I'd suggest that it is.
Yep.
If I can assist your lordships further.
No, I don't detect any more questions. So
Maybe about 2 minutes.
thank you very much, Mr. Morris. Ms. John.
I'm also conscious that I've done a lot worse than Mr. Morrison in timekeeping, and mindful of your lordship's indication that you want to retire to
Yes.
see what, if anything, you could tell us this afternoon, for which we're all very grateful. I just have 3 very short points.
Yes.
And the first one, and perhaps the most important one, is my learned friend entirely failed to deal with the problem he faces in relation to Smith, which is that even if he can show you that these emails could be read in the way he'd like you to, you have to be convinced that they could not be read in the way that I have been submitting, and that simply is not something he can overcome. That's the first and most important point. The other 2 are much more minor. One is that what he asks, posited the question right at the end, what is the value that Coupang get? Well, the value that Coupang get is that Nava, its arch rival, for example, doesn't get the rights. And you will have noticed, we're not talking the right to broadcast. We're not talking about tens or hundred millions of dollars, which sometimes football rights can go to. These are fairly minor football rights in this particular territory. And that's what it's actually getting. Now, I'm conscious that apart from my learned friend Junior Damien and those behind me, I was the only one below. But we've seen the particulars of claim, which sets out the injunction. We received a draft order, what they actually wanted, only on the morning of the trial, and it was in very different terms, and the matter evolved from there, is all I'm going to say. So I don't think it really helps to say we pleaded it, because in fact, it went one way and then another. So there was a moving position in terms of the draft order. But I do say that NAVA gets a value, and I do say that they paid for that, not a small amount of money, not a big amount of money, for these types of
Coupang.
Coupang, I'm so sorry, you're quite right. And so
What's the answer to the point that if you're right, you could post the feed on Nava's platform?
Well,
So the
that
benefit is that Nava don't get the rights, but I don't think that makes no difference if you're entitled to post a feed on a Nava platform.
Yeah. That's not one we operate or own or is one of our distribution partners, hence the additional verbiage, if I could put it that way. But for clarity, that's why those words are provided. So it has to be
Why would it be
an
different to
existing.
YouTube? Just don't upload it to their platform and put your branding on it.
I'm sorry, my lord.
Why is it any different to YouTube? You just don't upload it to the Nava platform, put your branding on it.
Well, that is not what the prohibition was asking for. We were not saying that's what we could do with our rights. We were saying it had to be our existing partners' distribution or channels that we operated. We don't operate a Nava channel.
But you don't operate YouTube.
No, we operate a YouTube channel. We don't own YouTube, but we do operate and have a YouTube channel. We don't own it. So
So what's to stop you operating a Nava channel? You may not have one now, but you could start one.
There may be answers to that, but I'm not readily to hand. My lord. I don't understand it. That's just not the way it works. So NAVA is not the same as YouTube in that regard.
I imagine not, but it doesn't really matter whether it's, you say the benefit is that NAVA doesn't get the rights.
Oh,
the
sorry.
benefit to Coupang is that no one else apart from DAZN gets the rights.
Well,
whatever
so
their,
I
whatever
agree,
their
and that's
platforms.
right. But what we're talking about is then what we then do with our rights, and that's different. And so I say that the value they get is they get the rights, not NAVA. Then the question is, what is my client, DAZN, able to do to exploit legitimately its own rights within that?
But the judge's point, I think, was you have to look at not only what you are currently doing, but what you could do on the wording that you say would fall outside the scope of the injunction, including reaching an agreement with somebody else to provide the feed through them.
Right, well, we entirely tried to provide the wording to make it clear that it was either a channel we owned, already operated, or through our existing distribution partners. That would not include their rivals like NAVA or the other, for example, rival bidders, my own wording.
So YouTube is a distribution partner.
Yes.
That's why it's not something you operate.
No,
It's a distribution partner in the sense that it is a platform run by somebody else through which you distribute the content.
that's correct.
And then what's to stop you doing that with somebody else? And that, at the moment, you have it with YouTube. You might have it with somebody else in the future. What's to stop that?
Well, I believe that the order was drafted in terms of our existing ones. So that's we were going to exploit our legitimate rights in accordance with the channels we already had up and running. That was what the drafting was aiming towards.
I don't think that either in the original drafting you proposed or in the revised one, it's limited to existing.
That's what I was trying to
This
get.
is why all of this debate seems to me to be so ill-considered, because the big difference, and this is why I keep on coming back to clips rights. I mean, clips rights is clearly a separate market, and you don't undermine exclusivity in a live feed by exploitation of clips. There are other, that it gives rise to other commercial sensitivities for reasons we didn't get into. But it is conceptually, at any rate, a distinct market. But if you're talking about the live feed going out on YouTube, that's a different ball game altogether, because anybody in the world can access it for free.
Well, it was a requirement of the FIFA head license that it was accessible freely in every single territory in which DAZN bought it. So that was a built-in, baked-in requirement of FIFA. So whether that happened through DAZN or whether it happened through the DAZN branded YouTube channel adds nothing to
You
the
said
point.
that earlier, and I'm still puzzled by that, because if there's a requirement that it's free to air anyway, why is anybody paying anything?
Well, I have asked that question, my lord, and the answer is the same way that you have NAVA and Coupang have their own apps and they want people to watch it through theirs. So they market and promote and get people to watch it through theirs. They don't pay tens and hundreds of millions of dollars for that. They pay a lower level to have that access provided, for example, to their existing users, etc. I agree that that is the way it works.
Does free-to-air mean not on a subscription channel or just not paid for specifically?
My understanding is that
But
free-to-air
again, I mean, my limited knowledge of the way football is made available in this country is that Amazon, for example, have on their Amazon Plus.
But see,
Now that involves a subscription, but it's free to air for all those who subscribe.
and the reason why we're having all of this debate is because this was all dealt with in a massive evidential vacuum.
Yes. No.
How can this court cure the evidential vacuum was allowed below?
I would actually agree with you, my lord. And I say that the evidential vacuum would have the judge in my submission fell into error by making a prohibitory mandatory injunction against my client against him.
Where was the submission you can't do this without evidence?
I believe I made that submission below to.
Well, it was on the transcript. That's an easy point to do.
perhaps I can do that while you're retiring to consider how you'd like to, because I don't want to waste any more of the court's time. I've already done.
Because I mean, this is not your ground of appeal.
No, I
This
understand
is
that.
what I'm coming to. Is I could understand a ground of appeal that said the judge below was quite wrong to do all this because he had no evidential basis, and we objected, and he was wrong because he proceeded in the face of our objection. There's none of that in your grounds of appeal.
What I was submitting to the court below, to the best of my recollection, I will look up the transcript, was that he could not rely on the problem was there was no definition of exclusivity, and the parties didn't know what it meant, and there wasn't any evidence for him to find that it did mean something sensible. That was the thrust of my submissions.
Because what I'm talking about is evidence as to, for example, what your YouTube platform consists of and what that involves.
I understand that.
And
too.
so-
He didn't have any of that. I entirely agree with you, my lord.
Yeah.
And I think this court will find itself with the same limitations, if I can put it that way.
And I'm not sure we're going to take things any further. The relevant transcript is the one at tab 15 as the supplemental bundle, is it?
Yes, it is. That's the.
And I can see discussion of the injunction. We move on to cost submissions by the end of
We do.
page 19 of the internal, or indeed a bit earlier, end of page 18 of the internal script. Oh, I see. No, I think the issue concerning the scope and the effect of the injunction should be dealt with by way of formal submission in the morning.
Second most distant from this, in the sense I was thinking tab 16.
Yep.
That's
That's where we really get to it, is it?
And exactly the way this comes out is that it's only in the course of the hearing, as far as I can see, and I'm coming to it as a third party in one sense, that the idea that this is a debate about live streaming the broadcast on YouTube is really something that's exposed. The judge clearly thinks originally this is a discussion about short clips, small amounts of content. Once that becomes apparent, the argument proceeds on the basis, on my learned friend's side, that it's not a breach, so don't injunct me. On our side, on the basis it is a breach. I don't think, and there's an argument it's premature because there's as yet no breach, that point is taken. But I don't think there's an argument the judge is not in a position to resolve that issue. I mean, I stand to be corrected, I'm conscious I wasn't there, but that was my reading of the transcript.
Yes, I see. At any rate, it's tab 16, not tab 15.
It is tab 16, and I'm trying to find the point, and I entirely accept that it has not been adumbrated as it has been now. But at page 273 of the bundle, and I say in short form it's between 7 and 11. It's an overreach in terms of
Which page on the manuscript?
Oh, I'm so sorry, it's 21 entirely. It's line 7 to 12.
Yeah, so that's the point about overreach. But where is the objection? You need evidence, and there is none.
I agree, it's a short form because it's saying that that's not been canvassed at all, either in the contract, it's not anywhere in the evidence, it's just not in there, it hasn't arisen for decision. I appreciate it's not expressly spelled out in those terms, my lord. And I'm sorry to say, I do keep getting interrupted, not today, but on the 22nd, you can see every argument he makes shows why this is a Horner's letter, my lord, instead of going beyond strict, and I was trying to say what's happening, what you've got before you. I wasn't permitted much time to make my submissions at all. It's not a complaint, it's the reality, I accept. That's what happened, my lord.
YouTube issue at page 275, internal 29. Yeah.
What this was is a shorter remote hearing, where sometimes
Yes.
these things are more difficult. So-
And the whole thing obviously was being done in a rush.
Yes, and I entirely accept my Lord Justice Arnold's point that I didn't spell out in absolute terms to the judge there wasn't evidence before him from either side, but I was attempting to say that it was an overreach. And when I say an overreach in terms of the contract, it's because there wasn't any evidence as to what that means in the contract, but I accept that that wasn't spelled out in those terms. The only other point I was going to make, and it's not really by way of reply as opposed to clarity, is that my Lord Popplewell asked about the heads of terms being subject to contract and then finalised. And it's right to say they were finalised and binding, but the way that that worked was that there was a term in there which said a long form agreement had to be entered into, notwithstanding that they were binding. So if that didn't happen, there wouldn't be an agreement ultimately, just to make that clear. That's the formal legal process steps. So you couldn't just have the heads of terms.
Unless there are any more questions, I think we ought to rise and see if we continue.
Great. We probably still need reminding on the live on YouTube.
Yes, I just watch out for the screen.
Perhaps on the court's channel.
If you go to our room.
Well, but they operate.
They did say no, no.
They suggested by 4:15, so I think when I started, but not just that. So I assume should we say we're just going to go away
Outside to avoid the screening issue. But if the judges come in before 4:15, there's something just going to pop that out. Thanks very much.
Don't forget you're also on YouTube.
Yeah, that's what I was thinking. Right. I know, because he also.
Yeah.
So yeah, so it was the same.
It was-
Yeah. Because then you know when they come.
you there, are they? That's fine. Thank you. Stranger things have happened, Craig.
Never know until you know.
That's very true.
Oh, okay. I need to figure my shares again, please. It's a big challenge.
They haven't said they're ready, but we'll just.
Just gonna ask, and then I'll let them know.
Okay, thank you.
Yes, you need to be careful with this. You know, make sure as of a basis, you can.
Where did you have to transfer it?
Oh, is it probably
Not to tell you how to.
probably not because sometimes it vanishes to them being reserved. You know, that's
The judgment bit, yeah.
Jamie, could you make a very careful note?
that's a good idea.
Oh, Jamie, someone, then.
You can say it myself.
What ready?
All rise if able.
Mr. John, Mr. Morrison, we've concluded that the appeal should be dismissed. The reasons will be given later. At the stage where they are given, you will obviously be provided with the judgment in draft for you to correct our typing and English, but not to re-argue anything. And we'd be grateful if at that stage you would seek to agree a consequential order. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. But thank you both for speaking roles, and thank everyone else involved for such helpful submissions today.
Am I right in assuming that we'll be sent a copy of the transcript?
Yes, I certainly hope so, and we'll make inquiries behind us to make sure that happens to your clerks, I assume, in the usual way.
Thank you very much.
Thank you.
All rise if able.